Well, welcome. We're glad to have everybody join us today as we take this cross-country and cross-cultural view of domestic violence, which remains the persistent barrier to women's enjoyment of their humanity around the world. I'm going to keep my intro brief today so that we can hear from the global experts on this topic, experts whose work is both academic and scholarly and grounded in lived experience and practice. To start, I want to make sure that everyone knows that we're going to be recording this and we're going to post segments of it in part or in whole on our public domain. So you can decide whether or not you want to change your screen name for anonymity, but we wanted you to know that in advance. My name is Denise Labertu of Women Lead Network and faculty at the California State University Northridge in the Criminology and Justice Studies Department. Women Lead Network is a collective of women who work to ensure that women's needs are central in discussions about world's problems and that they're engaged as leaders in the solutions to those problems. This includes all who identify as women, as well as femme, gender non-binary, and other birthing folks. Women Lead Network is sponsoring today's event. I want to recognize that we at Women Lead Network have built our lives and homes on the unceded territory of Indigenous Californians and acknowledge their elders past, present, and emerging, recognizing that the first people of the land are still here, and we are committed to lifting up their stories, culture, and community. Today, I'm joined by my colleagues Kimberly Wong and Abby Sims. We'll review a variety of approaches to addressing domestic violence in the United States, including moving beyond trauma-informed into nurturing resilience, the importance of recognizing domestic violence as a public health problem, and approaches to structuring legal schemes that are broad and diverse. We'll be joined by legal scholars from the National Law University of Odisha, India, who will provide an overview of the work that they're doing on the ground in communities throughout the region to understand the implications of domestic violence in India and develop solutions and promote offender accountability and survivor autonomy. We'll close with student scholars from California State University Northridge of the Criminology and Justice Studies Department, sharing their work using a human rights framework to reveal the implications of domestic violence for vulnerable groups. Chandra Mohanty, in her book Feminism Without Borders, speaks of her work as imagined community. She uses this language because it suggests potential comradeship and alliances across divisive boundaries and the idea of horizontal comradeship. She reminds us that building a transnational feminist practice requires solidarities across divisions, place, identity, class, work, and belief, and so on. We welcome you into this imagined community as we practice solidarity across divisions, and we hope that you continue to consider your work in this context. 30 years ago, a pioneering, diverse, multicultural group of women and other advocates recognized and documented that while strides had been made in women's empowerment around the world, progress was not quick enough and was uneven. They also noticed that advancement towards women's equality was littered with obstacles requiring urgent action. Since the Beijing Declaration and Platform for Action in 1995, women's human rights remain a critical issue. While some progress has been made, the stubborn structures of patriarchy have weaponized access to healthcare, economic independence, and political participation for women around the world. While women have fought their way into courtrooms and boardrooms, their roles within the private sphere endure largely unchanged. While violence against women in the public sphere continues as central to our public efforts to address women's safety, women's experiences of violence in their home remains largely invisible. Today, we're going to take a look at the global prevalence, impact, and potential strategies to address violence facing women in the home, family, and in intimate relationships by bringing together a new group of pioneering, diverse, multicultural women and other advocates, activists, students, and scholars from a variety of backgrounds across the globe to explore the issue of domestic violence in a global context and present research and solutions to finally surmount this obstacle towards women's equality. So I'd like to start by turning your attention to the work of our colleagues and scholars from the National Law University of Odisha, India, Dr. Suman Paramishra, Ms. Aroshika Mohanty, and Advocate Kumar Mukherjee. We're going to turn to your work at this time. Thank you for joining us.
Thank you, ma'am. So should we begin now?
Yes, please begin.
Aroshika, please share the PowerPoint presentation. Thank you. And before we begin, I'll just lay out the structure here. So Aroshika and Agna will be presenting portions of the presentation that we have for today, and we'll be starting with Aroshika for the first few slides, followed by Agna. We'll be going through the structure of laws in India, the structure governing the domestic violence legal framework, and whatever other structures that exist as part of the legal framework and as part of the broader rubric of the justice delivery mechanism. And we'll then take you through a few judgments, and we can then see how Indian courts have looked at domestic violence and why it is a proposition that as long as interpretation is not based on contextual reasoning, we will not have a justice trickling down to the victims for whom the justice system has been designed and for whom these special laws have been designed. And thereafter, we'll take you through the work that we're doing in the domestic violence project at National Law University, Odisha, and this will be followed finally by the work that Aroshika is doing on one-stop centers, which are like the one-stop crisis centers in the United States and in other parts of the world as well. So on this note, over to you, Aroshika, for making the initial remarks.
Thank you so much, ma'am. So as we all know that intimate partner violence, whether domestic or dating violence, it is a serious issue in India as well as worldwide, with significant implications on women's health and human rights. Globally, at least 1 in 3 women have been subjected to violence, especially with abusers someone known to her. And nearly 40% of Indian women have experienced violence at some point of their married lives. Now I'll show you some statistics. Now this statistics is from the National Commission from Women. This statistics is from the year 2024, where about 25,000 cases were registered for violence against women, and a staggering 24% cases were against domestic violence. Looking at the National Crime Bureau report, which records criminal cases, it has stated that by 2022, there has been 4% rise in crime against women in India. And while the report shed light on the alarming statistics, domestic violence has risen by 31%. And not just that, we can also reflect on the underreporting that since there have been a lot of underreporting, we are expecting the number of cases to be much more than this. So here are some graphs where we can see that about 12%, 12.9% rise in domestic violence cases from the year 2018 to 2022. Moving forward to the NFHS data, which is the National Family Health Survey data, it has also stated that about 43% women are abused of domestic relations. Now moving to Suman ma'am. Ma'am, you're on mute.
Arushika presented some vital statistics in the Indian context, and as you can see, more than 40% of women every year face domestic violence in some form or the other in India, and much of this goes unreported. Now, she stated two kinds of reports, as you may have seen, the NCRB, or the National Crime Records Bureau report. Okay, this is the one that she was referring to. And then she was referring to another report, which is called the National Family Health Survey, or the NFHS. So one might have the question as to why we are referring to two different kinds of reports here. And I thought it better to address the issue before we move forward. So the National Crime Records Bureau is not a very strong indicator of the exact number or exact fraction percentage of domestic violence in the Indian context, because much of the data is based on the findings are based on the number of acquittals as against the number of convictions. So which means that because, in domestic violence cases, as is the case in other parts of the world, also from what we read, in India also, most of these crimes are committed, but because of a bad prosecution or because of lack of evidence or some other issue, we find that the acquittals are much larger than the convictions. And Law Commission reports have used the NCRB data actually to state that domestic violence is not a frequent phenomenon, and the domestic violence legislation can now be done away with. So this is the bigger challenge that we are facing. To counter what is already there in the NCRB, we then rely on the NFHS. Now, NFHS findings are very important because the National Family Health Survey draws its information from women who visit hospitals or women who undergo medical treatment. And we find that most of these women who approach hospitals for medical care are women who have faced some form of domestic violence, mostly physical in nature. So most of these cases are about, let's say, issues of marital rape, where the woman has been injured, or where the women have fractured limbs, or where they have been attempted to be murdered or poisoned. So as you can see, on the left hand side, there's a table which talks about the findings in terms of percentage of domestic violence among women in the reproductive age group 18 to 49 years. And we find that certain Indian states, Haryana, Punjab, and then you have Delhi, the percentage in these states, the NFHS data has shown that the percentage of domestic violence is much more as against certain other states. So to depict the kind of things that we are facing currently, and the entire presentation that we have designed for today is based on the idea that domestic violence in India, although it is presented as something which is not a very big problem, because because women are abusing the law, or they're abusing the system. The reality is something else when we look at it on the ground level. So the first case that we have for you here, and this is what has happened in the last few months, is the case of Shraddha Walkar. And this is the case of a woman who was in a live-in relationship with her partner, and one day she's found murdered, dismembered. Her body was dismembered, and these body parts were stored in the refrigerator, later on packed into polythene bags, and then fed to animals in nearby jungles. The very sensational Madhavi murder case, which has happened very recently, it's about the case of an army Jawan who was retired from the Indian Army. His wife was about 35 years old, and she was killed by her husband. Her body was chopped, and then a very brutal murder took place with various parts of her body being pressure cooked and then dumped into a lake. So these are very disturbing events. But the reason we are investigating the problem of domestic violence in an atmosphere which is in an atmosphere which is very negative or very resentful towards domestic violence legislations, especially among men's forums, men's welfare forums, and men's welfare trusts, is because these are real cases of domestic violence, the ones that we're talking about, and they never make their way through courts, at least not successfully. So our understanding is that if domestic violence is stopped at a nascent stage, that is, before it translates into a homicide, I think lives of many women can be saved in the process. So this and the other thing that we want to put across is that in India, I think everyone must have heard about a very infamous rape case where the profile of the rapist denoted that he had been, he had been accused of committing various episodes of domestic violence on two of his wives. And both of them had filed FIRs at police stations against him, but no action was taken. So if you look at the profiles of criminals also, many of them are used to committing domestic violence. So we think that justice begins from inside the house. And if we can rectify things inside the house, perhaps the larger reflections on society will be very different from what they are today. Arishika, could we move to the next slide? So I think Agna and Arshika will be dealing with these portions, but I'll just introduce you to what this is about. This is about India's tryst with the domestic violence legislation. So currently in India, we have several laws which in one way or the other deal with domestic violence. So we have the Indian Constitution, first of all, which guarantees under Article 14 the right to equality, and under Article 21 the right to a dignified life. And we have civil statutes, we have a quasi-civil law in the form of the Protection of Women from Domestic Violence Act, and we also have criminal laws that deal with domestic violence, whether it's in the form of Section 498A of the erstwhile IPC, which is now the BNS from 2024, Bharatiya Nyaya Samhita, or whether it's a 304B, which deals with dowry death, or the Dowry Prohibition Act of 1961. Arishika, if I'm not mistaken, it is now Agna's turn to deal with these slides, right?
Right, ma'am.
Yes. Agnes, so over to you.
Okay, thank you so much, ma'am. First of all, it's a great opportunity to be delivering this talk and presenting this. As ma'am rightly pointed out, the facts regarding the laws. However, I would like to start off with a quotation saying that domestic violence is not just a woman's issue; it is a human issue. It is a societal issue. Similarly, if we go back to the previous slide, we can see that in India, we have approached this problem from a tripartite way. Now, what is this tripartite way? Now, post-independence, as we know, most of our personal laws have been derived from, or most of our marriage laws have been derived from religious customs and texts. So, in the civil sphere, we have amended our marriage acts, be it the Hindu Marriage Act, Special Marriage Act, Muslim Women's Protection Act, and have incorporated certain sections, just like cruelty, which start off by being grounds for divorce. Slowly, you will see that there was a snowballing effect. In the year 2005, we introduced the first ever Domestic Violence Act in a South Asian country. India was the first of its kind. Then later on, we saw that there were amendments made in our penal code. Now, India is not exactly the system in India is a bit different here. States cannot have their own penal statutes. So we have one uniform penal statutes, the Indian Penal Code, currently known as the Bharatiya Nyaya Sanhita, which, even though was introduced in 1860, it took them almost 100 years in 1983 to add the section on cruelty, which was one of the first sections of domestic violence in any statute in South Asia, followed by in 1986, where we added the dowry death section, section 304. Now, dowry is a concept where the female brings a certain amount of wealth from her house to gift the males. Now, from the onset, from the definition, we can see it is a deeply flawed and problematic concept, which unfortunately still in 2025 exists in the Indian sphere. Now, we can see that all three laws and all three spheres of laws have dealt with it differently. If we go to the next slide, we can see, if we go to the next slide, we can see that it basically tries to deal with the notion of patriarchy, which is deeply entrenched in Indian society. What I want to say, what I mean by that is that we use these words, patriarchy, societal imbalances, very loosely sometimes. But in Indian society, not just from Hindu laws, but also other laws, which are basically by the name we can detect that they are derived from religious texts, have actually allowed or somewhere sanctified these customs. So, since the laws are derived from religious texts, we can see that there is I don't want to say tinge, but there is a shadow of patriarchy in these laws. Now, this basically enforces the structural inequality which have been there since the last thousands of years. However, there have been amendment made to make sure that this is mitigated. Now, these amendments are opposed, or these changes in laws are opposed constantly by the forces who claim to patronize women or who claim to protect women in the guise of patronization and say that it is not sexism, but rather it is benevolence. No, actually, it is a concept known as benevolent sexism, where women are treated as inferior and are treated as beings who need to be protected. And sometimes it also leads to hostile sexism or domestic violence. Now, this word, patriarchy, it also generates or it also puts a patriarch. Now, in Indian law, there is a concept of Hindu undivided family or the karta of the Hindu undivided family. In Pakistan, Bangladesh, Nepal, they have their own renditions of the same, but basically the concept is same. It's basically enforcing the concept of a patriarch. Now, that patriarch becomes, you can say, a silent role model for the other generation or the younger generation, and there is intergenerational transmission of the same. Now, in the next slide, we will see that what kind of problems it creates. Almost 80% of Indian men and women in a recent study believe that it is better if the women take a subservient role or take a role of obedience in their own way to the man. So the woman is the second lead or the second captain of the ship, and the man is the first captain. This also enforces and further solidifies the demands for things like dowry, and there is a concept of stridhan. Stridhan is a wealth which the woman, even though in her own name, brings to her in-laws family. That also has led to a lot of exploitation. And when women or other forces of the society try to speak out against it, they are silenced by saying that, oh no, it is a private matter, it is a personal matter, it's between the husband and wife, please don't interfere. And this is how voices are silenced. In the next slide, we can see that there is also certain problems which are there because of these concepts. Even today, half of Indian women are either not working, not allowed to work, or due to internal restrictions imposed on them, do not prefer to work. This creates a huge power shift, or this basically shifts the power, the economic power, in the hands of the male or the patriarch of the family, as a result of which there is a indirect dependence of the woman on the family. Also, there is stigma, and there are other factors which are affecting women, as a result of which they are not only scared to speak out, but sometimes they are silent victims and they don't even recognize themselves as victims, or they don't even know that they are victims. Rather, they think that what is happening to them, they deserve it, and unfortunately, in some cases, they blame themselves. In the next slide, we can see in the next slide, we can see that to counter or to break this notion, Indian jurisprudence or the Indian legal sphere introduced its own objects. For example, the most powerful tool against domestic violence in India till date remains the Protection of Women from Domestic Violence Act, an act which came in 2005. There are sections of the Indian Penal Code, also known as the Bharatiya Nyaya Sanhita after the recent amendments, and also other statutes like the Prohibition of Dowry Act 1961. Now, if we go through these laws one by one, the protection, the Domestic Violence Act, I'm calling it the Domestic Violence Act for short, is basically the most impactful and the most important act. Why? Because number one, it defines what is a domestic relationship, what are the different types of domestic violence, how it has, in the next slide, when we talk about the cases, how it has almost taken a life of its own and organically incorporated live-in relationships. And I was baffled to see in a recent judgment, even cohabitation is not necessary, and it has, let's say, arguably recognized dating violence. So this is the beauty and this is the glory of the 2005 Act. And till date, it remains one of the most effective tools in countering domestic violence. Now, if you go to it, if you look at this slide, it basically reinforces what I just said earlier, that it defines what is domestic relationship, domestic violence, what are the different reliefs provided by that. Since it is quasi-civil in nature, it doesn't exactly impose a penalty, or it's not exactly a penal statute, but it can be used as one. If we look at the other laws, for example, the other sections which are incorporated in the Indian Penal Code, or currently known as the Bharatiya Nyaya Sanhita, although the sections have changed. If you go to the next slide, okay, it talks about the cases. So I would now like to request my research fellow, Orushika, my colleague, to kindly take it from here and talk about the different cases, like the current case, Indra Sarma versus VKV Sarma. Thank you.
So, as Kumar mentioned, that the Protection of Women from Domestic Violence Act has incorporated live-in relationships. So, this judgment is a welcoming judgment where it has considered relationships in nature of marriage, such as live-in relationship, to avail reliefs under the Domestic Violence Act. Moving further, in this case of Harsora, it was stated in the statute, it was mentioned that a victim can file a case against a male adult respondent. But with this judgment, it got away with the adult respondent and it was replaced with any person, giving the victim a broader area to file case against either the families in the matrimonial house.
Arishika, maybe we
Moving further to
the next slide. Okay, I'll begin from here. So while Agna and Orishika were discussing the PWDVA, I would like to mention three major aspects of the Act, which we need to remember as we progress into the presentation. First of all, the Protection of Women from Domestic Violence Act, or the DV Act, is the first of its kind to recognize 5 different kinds of domestic violence. So the 5 categories are physical violence, mental violence, economic violence, verbal violence, and sexual violence. Now, this is important because in earlier legislations, which was primarily 498A of the IPC, only physical and mental cruelty of a certain degree were considered to be matrimonial cruelty or domestic violence. So the ambit of domestic violence was widened by the PWDVA. Secondly, while we say that Protection of Women from Domestic Violence Act is a very well-crafted legislation, it has one major drawback. For its implementation, it is dependent on an entity called the protection officer. So any order which is passed under the Protection of Women from Domestic Violence Act of 2005 by any court will have to be executed by the protection officer. In India, we have had the problem of non-recruitment of protection officers on a large scale. And even today, if you look at a state like Odisha, which has 30 districts, you have 30 police protection officers. In every district, you have one. So every district gets one protection officer, as against the number of cases which come from every district. So what happens is ultimately, if the protection officer is absent or has not been appointed, or the post remains vacant, then the execution of the order passed by the court becomes a massive problem. The good aspect, I mean, very actually a very welcoming aspect of the DV Act is that it is one of those legislations which understands the many problems that a victim of domestic violence is likely to face. Now, we have always maintained that a victim of domestic violence is not an ordinary victim, because she is one of those victims who might be fighting several cases in courts simultaneously. So there might be a custody hearing going on somewhere, there might be a divorce hearing going on, she might be, wanting maintenance and might be, approaching the court for interim maintenance or for meeting litigation expenses, or she might have been thrown out of her house and might need a roof over her head and might be fighting a case in court regarding that also. So all these solutions have been offered under the Protection of Women from Domestic Violence Act, and in a way it has cured and remedied the narrowness of the criminal provision, because the only benefit that could come from the Indian Penal Code for victims of domestic violence would be incarceration of the husband. Whereas incarceration is not a solution in the Indian context, where women are heavily dependent financially, emotionally, socially on their husbands. So very often women used to withdraw these cases from the police stations, and drop the hearings and would not attend hearings, even though the criminal trial would be taking place. And that's how many of these acquittals resulted, not because the case was fake, but because the victim did not want to continue with it. So the PWDVA offers several solutions. It allows the magistrate to pass orders such as residence orders, protection orders, economic orders for maintenance, so on and so forth, and that also includes custody orders. Now, before we move ahead, a little bit of introduction to 498A of the Indian Penal Code, which remains the very first anti-domestic violence legislation in India. It was inserted by an amendment in the year 1983. And as you can see, for a person, for a perpetrator to be brought under section 498A of the Indian Penal Code, or 85 of the BNS now, willful conduct on the part of the husband is necessary, or a relative of the husband is necessary, but it has to be of a certain extent, that is grave injury to life or danger to life, limb, or health must be there. And harassment may be related to the giving and taking of property, unlawful demand for property or dowry, or it could be for any other purpose. So both non-dowry torture and torture which is for unlawful, which is based on unlawful demand or coercive demand from the spouse, are covered in this section. Orishika, could you move the slide? So I'll be now taking you through the next slide, Orishika, through a few cases, and we'll be trying to see the interpretation of 498A by the Indian judiciary over a period of time. So in the last decade, actually a little over a decade, the Supreme Court of India has come down heavily on criminal prosecutions for domestic violence, and also the use of the DV Act of 2005. So there is a predominant opinion that you get to read from media, that victims of domestic violence are abusing the system, are abusing the law, and the Supreme Court, in one of its cases, has gone to the extent of saying that these victims are only disgruntled women who are unleashing legal terrorism on innocent husbands. Flavia Agnes, one of our very vocal and a very active feminist in India. She has been talking for a very long time about the use of such pejorative terms for victims of domestic violence. So she says, who are these people that you're calling disgruntled women? These are women who have been burnt, who have been beaten, who have been abused in ways that one may not be able to even imagine. So when the Supreme Court says that these victims of domestic violence are actually women who are disgruntled and who are abusing the legal process, the Supreme Court needs to think twice before making these allegations. So how and why did the Supreme Court form this opinion? And why is it that we are continuously referring to the idea of abuse of domestic violence laws? Now, this has a lot to do with media reports. This has a lot to do with how we have been dealing with domestic violence cases. Of the reasons that that you may read and the ones that we have experienced, some are very important. So firstly, women have been seen to be, as I said, withdrawing cases from the police stations. But secondly, the interpretation of the law has resulted in several acquittals. So whether something qualifies as cruelty in the criminal sense of the term is a question of fact, and every case is treated in a different manner in courts of law. But what happens when we do not use contextual reasoning, as we know, as all of us here would know, is that we arrive at conclusions that are bizarre. But these bizarre conclusions taken together also create an almost insurmountable world of acquittals. And we look at the figure of acquittals, which is currently 83%, as stated in the 243rd Law Commission report, as against only 17% of convictions. So when we look at these numbers and numbers alone, without getting into the details of why these cases resulted in acquittals, one might assume superficially that this is because the court thought that the cases were frivolous. Now, our point here is that these cases are not frivolous, but the acquittals happen because judges choose to adopt a certain method of interpretation, which doesn't really lead to any justice coming down to the victim. So I'll just give some examples by referring to a few cases. Now, this is one of the Indian cases of 2014, and the name of this case is Mangat Ram versus State of Haryana. So there are certain forms of evidence that we can't weigh. Now, if you look at what is written on this slide here, you will see that it is an extract from a letter. Now, most domestic violence cases in the Indian context are cases like Mangat Ram, where now the woman might be in a village, and as you know, Indian marriages are patrilocal mostly. 95% of marriages in India are patrilocal marriages. So which means that the woman marries into the family of the husband. So she starts living with the husband and his family, and because most of us have a joint family system where it's common for the women to live with the parents of the husband along with other relatives of the husband. So, so you may not have many witnesses in favor of the victim, and that is one of the reasons why 498A and 304B were conceptualized in the form that they are. They have been drawn out at present. So if you look at the content of the letter here, the victim writes a letter to her parents stating that you should come. It's very important work. If you do not come, then I'll give my life, by which she means that I'll die. Therefore, both of you should come. Even if Somnath Mama will say no, but you have to come. What more can I write? You're wise enough. If there is any mistake in the letter, then forgive me. But you have to, come. Otherwise, I will not be able to live. Then look at the final sentence where she says, if you will not come on 25th, 5th or 26th, then on 27th, you will get a telephone call of my death. Arushika, could you move the slide? So in this case, it's very interesting that the woman has been shifted from her from the house of her husband to the house of her parents. Like several times she has been shifted, and then finally one day the husband decides that she should stay with his parents, and he should join his service at a different place. And he never comes back and takes the wife to his own place. Now, after there are many instances of cruelty in this case, where she's been taunted at, where she doesn't want to stay because she's suspecting an extramarital affair of the husband, but none of this is taken into consideration. And the Supreme Court says that although she has died, the death has to be presumed to be accidental, because she was suffering from epilepsy, and when she was in the kitchen, she might have fallen on the stove while cooking, and she might have caught fire, as a result of which she might have died. So this is not one case. Even today, while teaching at the Judicial Academy, I was citing examples of several other cases where the Supreme Court imagines that anything other than what the prosecution's version of the victim's death is quite acceptable in court as the reason why the woman might have died. But when you look at these cases and you look at the evidence, and this might be the only form of evidence that is available to the court, and even if the court comes to a conclusion of acquittal in this case, as you would imagine, as you would assess while looking at this case, it's not a case of frivolous complaint filed by the wife, but one of cruelty which she was not able to prove in a court of law, because the evidence was not enough to meet the standard, the standard of the barred principle, or the beyond any reasonable doubt principle. Arshika, could you move the slide? Then there's a case of Meka Ramaswamy versus Dasari Mohan. It's a 98 judgment. Now in India, dowry is very often the cause of death. In this case, the trial court and the high court both acquitted both acquitted the accused on the ground that even though suicide has been committed within 4 months of marriage, and even though other evidence for dowry have been presented before the court, the court cited the reason that financial condition of the victim was known to the respondents. Therefore, there's no possibility of dowry. So no other evidence was taken into consideration to decide, because the court believed that if the financial condition of the victim is known to the respondents, there's no chance for them to claim any more dowry from the victim. but I will cite a societal reality here. So very often women get married and they settle for some amount of dowry, but the parents of the husband and the husband himself, they keep demanding more and more dowry over a period of time, and doesn't have to do anything with the financial condition of the victim. And in law, there's a presumption, in criminal law in India, there's a presumption that if death has occurred due to unnatural circumstances within the first 7 years of marriage, then there's a presumption that, and there has been some element of dowry, some allegation of dowry, then the presumption is that the death may have been a dowry death. So the court begins proceedings with that presumption. Despite that, you have decisions like this one. Sushil Sharma versus Union of India is a case where the constitutional validity of 498A was challenged, and the Supreme Court upheld the constitutional validity of 498A. But Sushil Kumar Sharma is a case where the Supreme Court laid down very vividly that 498A is grossly abused by women. They did not have any data to rely on, and the Supreme Court stated that dowry harassment and cruelty are no more issues for modern Indian women, and we should be very careful, and we should constrict the scope of the anti-dowry legislations and the anti-matrimonial cruelty legislations. But interestingly, Sushil Sharma's case is also one of those cases where the woman was killed and her body parts were cooked in the tandoor. So it was famously known as the tandoor murder case. So for the Supreme Court to pass a decision on restricting the scope of 498A in a case like Sushil Kumar Sharma's case, this is something very unfortunate. Then you have Preeti Gupta versus State of Jharkhand, where again, the Supreme Court, without relying on any data, came to the conclusion that domestic violence complaints need a much stricter scrutiny, and women have been abusing the law, and victims are facing, delays in registration of FIR, but that's all right. And we need to ensure that women do not come to police stations and do not take immediate actions in cases of domestic violence in the form of criminal litigation. The next case, Lalita Kumari versus State of Uttar Pradesh. It was a case where a preliminary investigation was mandated in many cases, and in those category of cases, they had an expression called matrimonial disputes. So which means that if there is a matrimonial dispute, before filing an FIR, a preliminary investigation has to be done. Now, the problem is that matrimonial dispute is not the same as matrimonial violence. So semantically, we see that most of these people who refer to cases of domestic violence where the woman has been beaten, has been physically abused, has been sexually violated, has been even hospitalized, as cases of disputes where there has been an argument between a husband and a wife. So these are not really very extraordinary cases, but rather the police refer to these cases as ordinary wear and tear of matrimonial life. Then you have Anish Kumar versus State of Bihar in 2014. And in 2014, this is supposed to be one of the most unfortunate cases, because in India, we have the concept of mandatory arrests for cognizable cases. And this provision, the anti-domestic violence legislation that we have, it in under 498A, it refers to it is a cognizable case, which means that a mandatory arrest policy can be followed here to prevent the escalation of an episode of domestic violence into that of a homicide. Automatic arrests were, essentially denied in Arnesh's judgment, which means that women, even though they face domestic violence, the husband will not be taken into custody. mandatorily and automatically. The practical consequence of Arnesh Kumar's judgment has been that many women were turned out of police stations to, not carry, and their complaints were not registered immediately. Not even the complaints did not even make an entry into the station diary. The next case is Rajesh Sharma versus State of Uttar Pradesh. Now, as I mentioned earlier, in serious offenses, in cognizable offenses, you do not really compound the offense. So, for example, if I were to say that if there's a case of murder, and in the case of murder, I'm now, as the court, I'm asking the victim to kind of compound the case with the to settle the case with the perpetrator. Now that would be bizarre. So we are essentially, Rajesh Sharma said that you should have an entity called the Family Welfare Committee to see whether a case of domestic violence can make its way into the stage of FIR at a police station. So this, the Family Welfare Committees actually encouraged mediation and conciliation in the grossest cases of domestic violence. And but fortunately, in 2018, the Supreme Court reviewed Rajesh Sharma's judgment and did away with Family Welfare Committee, stating that it is this is something which cannot be sustained constitutionally. And then now in 24, again, we have Achin Gupta's case where the court seems to be playing its music back again of saying that we have a lot of cases of domestic violence and there's a lot of abuse of these cases. So again, without any reliance on data and based entirely on their understanding of what DV problems are, and it has now again asked for further restriction of domestic violence laws. Now from here, Arushika, could you move to the next slide? So I'll just be touching upon, because we are, running short in time, and I'll just be touching upon the fact that marital rape remains a persistent problem and one of the grossest forms of domestic violence in the Indian context. And even today, we do not have a marital rape legislation. The only way one could penalize the perpetrator for marital rape is by seeking recourse to 498A of the Indian Penal Code and its corresponding provision in the BNS. I mean, the IPC is now called the BNS, right? So the only development has been that earlier, if there's sexual intercourse with a minor wife who was below 15 years of age, this would be considered as statutory rape, and exception 2 to the rape provision would not apply. But this age limit has now been expanded from 15, it has now become 18 years of age. So the 3 years, it has been enhanced by 3 years. And this change was brought about by this very famous judgment, the Independent Thought versus Union of India. And now in the BNS, you don't even have to rely on this judgment. The BNS has made it very clear that sexual intercourse by a husband with a minor wife, the wife being below the age of 18 years, will constitute marital rape. But for women above the age of 18 years, there is no marital rape provision. I mean, anti-marital rape provision. We'll move to the next slide, Arshika. And the next one. Yeah, so the DV project at NLU is called Addressing Domestic Violence in Odisha through Institutionalized Domestic Violence Response Protocols. So what are we looking at? So as I said, most of the remedies that courts could bring to the table for victims of domestic violence are lost in translation in Indian courts. The way we interpret our laws has led to more acquittals, and the way acquittals have been interpreted at various levels is that women are abusing the law. Now, the entire picture of women abusing domestic violence laws is based on the number of acquittals. So through this project, through this research, we are looking at all these Indian cases and why courts acquitted the perpetrators in these cases. And then we are going into the field to collect the lived experiences of women who are at shelter homes, who are at one-stop centers, who are usually victims, who have been thrown out of their houses, or destitute women. And we engage with them and with other stakeholders, like people who run the NGOs for women who are victims of domestic violence, or the police, the judicial officers, lawyers, protection officers, civil society organizations, and even legal aid authorities. We collect data from these stakeholders at multiple levels, and we engage in qualitative research to find their views and opinions and their experience of dealing with domestic violence victims, and the victim's perception of what the judiciary and the police are doing with respect to their rights. So our goal here is to collect data from multiple stratas, organize them, and then look at patterns and deviations as far as the problem of domestic violence is concerned. So currently, we are in the process of collecting data from victims, for which we are organizing focus group discussions. And after this, we have organized our stakeholders into multiple cohorts. And in the months of June and July, May, June, and July, we'll be conducting interviews for judicial officers, focus group discussions among the police. Actually, now we have already collected data from 500 plus police stations from across Odisha by conducting interviews at police stations. We also visit shelter homes to see the conditions in which the victims who are, put in these short shelter homes live, and what kind of capacity building measures go on. And at some stage, we're also, towards the end of the year, going to have consultation meetings with legal aid authorities to find out what happens to indigent victims of domestic violence. Then we have some initial findings here. And these our initial findings are, first of all, a lack of structural clarity. So it's not that the government hasn't taken any measure for victims of domestic violence, but it has created, entities which operate as islands of isolation. So which means that you have the police and you have a one-stop center, but the woman may not be able to reach the police station because her family will object to it, and because she might not even have 20 rupees or 30 rupees to take a bus or an auto to cover 15 kilometers and then reach the police station. There's a lot of structural clarity in terms of how women's issues will be dealt with. So who is the person in the police station, for instance, who will be dealing when a case of domestic violence comes in? So there's a lot of structural clarity there. There are inter and intra-institutional barriers. The court passes a judgment today, but the judgment is misinterpreted by the police. So, for instance, with what happened in Lalita Kumari's case, the court said that preliminary investigation is required for matrimonial disputes. It did not ever mean that to have preliminary investigations in cases where the woman has visible physical injuries. But a lack of understanding of the judgment of the court resulted in the police, organizing preliminary investigations, conducting preliminary investigations even for women with visible physical injuries. Then victims' inability to access existing mechanisms due to various factors. Sometimes factors are structural. As I said, there's no money, so I have to walk all the distance of 10, 15 kilometers to reach the police station. Otherwise, it's sometimes also functional. I go to the police station, but I'm illiterate and I can't write my first information report. So somebody has to write it for me, and I don't even know what goes into my first information report, because the police have no set mechanism of aiding and assisting somebody to write the FIR, and it is entirely dependent on whether whether you have a soft-hearted or a kind-hearted police person to help the victim with it. Then you have existence of parallel mechanisms. So parallel mechanisms, as in India is a country, Odisha specifically is a state where caste plays a very important role. So you have caste panchayats, so which are not really recognized by the government or by the law, but these exist to decide on cases of domestic violence. There's a lot of emphasis on conciliation and mediation. The police are not really trained to conciliate or mediate between the victim and the perpetrator, but but we see frequently the police trying to conciliate and mediate, and judges in courts emphasize that marriages should be saved, and therefore divorce proceedings take a lot of time. And in the meantime, if there is a case of 498A, then or whenever there's a case of 498A, even if it's a criminal prosecution at the cost of the victim's life, courts and the police and the society at large, they expect the victim to go back and stay with the perpetrator. This is more so the case when the victim and the perpetrator have children. Then there's a lot of victim blaming. The victim is found to be unreliable, and a larger societal inability to comprehend domestic violence as a crime and not a dispute. So if you hit your wife, you don't call it a dispute anymore. It's a crime. It's violence at many levels. But in the Indian society, hitting the woman is looked at as a dispute, as ordinary wear and tear of life. And sometimes people go to the extent of saying, he hit you because he loves you. So this is where I would like to stop. I think we are out of time, Professor Denise. So even though Arshika would have wanted to say a few words about her one-stop centers, but I don't think we have the time for it. I leave it to you.
Okay, thank you so much. So we do have a little bit of a time issue, but Aroshika, if you'd like to, I don't know if you're able to stay on, but I can also allow you some time sort of later if that works, or do you want to just talk about it very briefly?
I can just talk about it very briefly in 2
Okay.
minutes.
Okay, great.
So one-stop centers, as we know that it is a one-stop solution to all victims. So the idea of one-stop center is to provide immediate relief to a victim under one roof. Now the concept of one-stop center came in 1970s. So there are 3 types of one-stop centers. Basically, a NGO run one-stop center where entirely the NGO takes over the one-stop center and provides relief to the victims. There are standalone one-stop centers which are community-based, and the hospital-run one-stop center. So now we are actually looking at the hospital-run one-stop center. So basically, the idea to locate a one-stop center at the hospital is to give the victim immediate medical treatment which she requires. So certain criteria for hospital-based one-stop center is that it is ideal that the one-stop center is located in the casualty department. Then very briefly, the history in India is that in 2013, it was recommended to set up one-stop centers. And in 2015, the scheme was launched under the Nirbhaya Fund. And basically it targets about women and girls over 18 years of age, and it has also collaborations with the juvenile justice home, so that in case a victim comes with a minor child, then the minor child can have an accommodation in the juvenile care home. So some features are that at least a one-stop center should be well equipped, and they should have at least 5 rooms within the hospital campus. In cases where there is no space in the hospital, then it can be located within 2 kilometers radius in any government facility. And in case if there is no government facility, then they can provide for construction of such one-stop centers. And in metro cities or in bigger cities, there are provisions of creating more than one-stop centers. So the basic services provided, basically all the services that a woman would require, a victim would require, are provided in a one-stop center. Like they'll connect you to a counselor, they'll connect you to the police, they'll connect the victim to a protection officer who can help her file a DIR. So all sorts of reliefs are provided in the one-stop center. Now, how to access a one-stop center? Through helplines. In India, we have the 181 helpline. So if a victim calls on the helpline, then immediately they can address the one-stop center officials to come and receive the victim from her house and to locate her at the center in case she is not willing to live in the house. Recently, the government has amended that short stay homes, the victim can shift to short stay homes within 10 days. Like in case she's not getting immediate relief, then she can stay in the one-stop center for 10 days and later be rehabilitated to the short stay homes. Now we see that this is a very good initiative, but in India with such a vast population, the one-stop centers are not being able to reach out to the people completely. So this is basically what my PhD revolves on accessing the efficacies of one-stop centers. Thank you so much, ma'am, for allowing me to speak.
Oh, there I am. Okay, of course. Okay, thank you so much. I know that it's late there in India. We invite you to continue to join us, but understand if you need to leave the meeting. If people have questions, I'm happy to forward them. You can ask them in the conference site, and I'll forward them to the team at NLUO. So thank you so much for your participation, everyone.
Thank you. Thank you, Professor Denise. It was a pleasure. We would love to have the questions and we'll promptly send our responses too. Thank you.
Okay, thanks so much. Thanks so much, everybody.
I seek
Thank
your
you, ma'am.
permission to log out. It's 11 in the night, past 11, actually 11:15.
Please feel free. Please feel free. Okay. Okay, so the next thing that we'll do is we'll take a look at some of the approaches that we've used to address domestic violence in the United States. Kimberly Wong, who's a clinician working with survivors and others who've experienced trauma, will help us to imagine going beyond trauma-informed and considering the ways that we can support survivors of domestic violence through building resiliency. Abigail Sims, who's a preventionist, will explore the role of the public health model in addressing domestic violence beyond the criminal justice system. And then I'll highlight some of the legal tools that we have available to address domestic violence in the United States. Kimberly, would you like to start? We can't hear you. We can't hear you.
Hi, everyone. I'm excited to be here, honored to be here, and thank you so much to my fellow co-presenters from India. I know it's late, and thank you so much. It was very interesting. I'm going to be shifting to more from working with people individually, and they presented a great information about the laws and systems within India. I'm a licensed clinical social worker, and I am I have a private practice, psychotherapy practice in California, United States. I began my career working with survivors of sexual and domestic violence. I worked as a volunteer crisis counselor and advocate. In the last 10 years, I have incorporated more of a somatic-based, body-based model, which is the community resiliency model, the trauma resiliency models. And this focuses on understanding how stress and trauma impact the body. And it looks at also the automatic survival responses and helping to build resiliency as part of healing. This model is both trauma and resiliency informed. We know that interpersonal violence is very traumatic, and it not only impacts people individually, but it also impacts systems, which my colleague Abby will be talking about later. So from an emotional perspective, some common reactions are people may experience fear, anxiety, anger, sadness. Physically, they may have problems with sleep, appetite. I'll be talking a little bit about the autonomic nervous system later. Thoughts could be changed in terms of like nightmares, dissociation, negative thoughts about self. People can have anger outbursts, isolation, which obviously can impact their relationships. And then spiritually, they can lose hope or have changes or loss of faith. Now, this is from the resilience perspective. We also look at common growth reactions after somebody perhaps has gotten through some experiences. And so some of these growth reactions that can come up are that, you know, people might recognize their own courage and strength. They may also become advocates themselves. There can be increased hope, compassion for self and others, and the building of new meanings. I'm going to skip this slide. There is a perspective shift. In the United States, we have the conventional perspective is the assumption that people are bad and need to be punished. We have a very big prison carceral system in the United States. So from the conventional perspective, the question that's asked is, what is wrong with you? Shifting into being more trauma informed, there's an awareness that people are suffering and that trauma, domestic violence, relationship violence can impact a person's development. And so there is an increased awareness. And the question then is, what happened to you, not what is wrong with you? Taking it to the next step, being resiliency informed includes also being trauma informed, having that understanding. And it has the additional recognition that people are resilient, that they can learn new skills to help with their healing, to reduce their suffering, and to build in well-being. So the question includes what happened to you and also what is right with you and what are your strengths. This is resiliency. The term has been often used against communities that have been oppressed. So this is the CRIM definition of resiliency, which includes compassion and empathy and the acknowledgement of individual and collective suffering as well as strengths. It's solution focused, and there is hope and the embodiment of well-being. Again, the CRIM model is a biological model. It focuses on what the trauma impacts the body, and this recognition that there are common reactions to stress and trauma, abuse, and everybody has a nervous system. So the focus again is on biology rather than the conventional perspective of mental weakness. And using the skills of CRIM can help individuals read their own nervous system and to help them connect to more well-being. Continuing on with the biological perspective, we look at the brain. And the brain has simplistically 3 parts of the brain. And I'm going to start at the bottom where it says survival network, which is the portion of the brainstem that forms in the very beginning. And it is unconscious. It carries out the functions of keeping us alive. So regulating things like digestion, heart rate, circulation, and breath. It is unconscious. It carries out the things we don't think about consciously. It responds to sensations. It does not respond to language. The next section is the emotional network. And this is the limbic area. And it connects to expression of emotions and feelings, attachment, and it also assesses risk. So it looks out for when there might be a threat, and it can sound off an alarm to potentially initiate a survival response. And so with threat being intimate partner abuse, violence, etc. The thinking network is the last part of the brain that forms, and we know that it's fully developed around the age of 25, and it involves thoughts, speech, memory, and language. So this is the part of the nervous system, the autonomic nervous system is part of the survival network, and there's two branches. And again, everybody has a nervous system, and these are the parts that regulate the parts we don't think about, like breath and blood pressure. So the sympathetic branch and the parasympathetic branch. And the sympathetic branch prepares people for action. It engages when we're exercising. It also engages when there's a threat and initiates like a fight and flight response. So heart rate increases, breath increases, blood pressure increases. It also initiates stress hormones. And if you're thinking about a fight and flight situation, like digestion and saliva decrease because digestion takes up energy, and what the sympathetic branch in that moment is trying to do is mobilize the large muscle groups to fight or flee. It is like the gas pedal of a car, the sympathetic branch. The parasympathetic branch prepares for people for rest. So when we're calm, our breathing slows down, our heart rate slows down, and our digestion increases. And we sometimes call this rest and digest. Along with so a foundation of the somatic models is this idea of neuroplasticity, which is essentially that our brain can continue to change and rewire itself based on new experiences and what we learn. And what this means is that there can be hope. So it can help create different neural pathways. So this brings us to tuning and pruning. Like, we can tune into positive experiences and build and strengthen those neural pathways in the brain. And pruning is shifting away from neural pathways that we want to decrease. And an example of, like, it's the use it or lose it principle. And I want to give a brief example that, like, I learned piano when I was a child, and I studied. I wasn't very good, but I learned piano. I knew the keys and the chords and what have you. And I haven't used the piano in decades. And I sat at the piano the other day and I had absolutely no idea what to do. I didn't remember the notes or anything. And so that's an example of some of my neural connections, because I didn't use it, they disappeared. So why this is important is that we can, as we learn to read our own nervous system, we can understand the differences between sensations of distress and the sensations of well-being. And then we also have a choice on what we want to pay attention to on the inside. So we can shift away from perhaps anxious thoughts of worst case scenario. If we aren't focusing on that and we focus on some other possibilities and open it up, then we can strengthen the neural pathways of like a more realistic thought versus continuing on with some of the negative thinking and sensations that go along with that. There's this concept of a resilience zone, and within this resilience zone, we can have ebbs and flows of energy. And in this zone, it's also considered the okay zone. It's not necessarily a happy zone. We can have higher energy, lower energy. We can have different emotions like anger, sadness, happiness, and joy, calm. All of that exists in the resilience zone. And when we're in this zone, it's when all of the three parts of our brain are working together, and we feel like we can function. We can manage life's problems. And the goal, as part of the goal of using the CRIM tools, is to widen our resiliency zone so there can be fluctuations within that to stay and manage life's problems. The thing that can happen is when there's a traumatic or stressful event is that it can move someone out of that resilience zone. So the three parts of the brain are not working fluidly together anymore. And sometimes it's almost like our thinking part of the brain is less accessible or goes offline. And so it's a difference of within the resilience zone of feeling anxious versus being bumped out of that resilience zone and feeling overwhelmed and panicked and unable to think. Or having anger outbursts where you're not able to control. Or depression, on the flip side, going low would be going from sad to like depressed and checked out, unable to get out of bed, that type of thing. So individual perception of is super important, because from a survival perspective and how our nervous systems respond, if it's how we perceive an event, if we perceive something as life-threatening, then our nervous system will respond in kind. And so it's not whether or not a situation is life-threatening or not, it's how it's perceived, and that becomes important. There's different, I did want to distinguish different kinds of ways trauma can manifest. There's shock trauma, which is like an event that comes very hard, like a natural disaster, an act of violence, interpersonal violence that's too much, too fast. And there can also be developmental trauma that happens ongoing. And so too little for too long would be more like neglect and poverty, ongoing like child neglect. And then too much for too long, you can see where this would fit in with relationship violence, intimate partner abuse, that's going, childhood abuse, that's going ongoing. One of Kumar from the, who presented earlier, talked about intergenerational violence. And then there's also historical violence, which is violence that's occurred to an entire community. I know that we're short on time, so I'm not going to spend a lot of time on the survival responses. But what I do want to say, again, with the nervous system, is that survival responses are protective, they're biological, and it's when there's a perception of threat to life or safety. And they become automatic a lot of times. I think many people have heard about fight, flight, and freeze. So I really would just kind of want to mention tend and befriend as a survival response, because it's lesser known. And this engages when people are like wanting to take care of offspring or children. It comes in when people are trying to connect with community, like the safety in numbers and getting protective support from like a group. And it also involves befriending the person who might be harming you. And you can see where this also fits in with interpersonal violence, because the idea is to connect or attach or befriend the person who's harming you might increase your survival. And so that's where it falls in a survival response. And there's the oxytocin can be released in the brain, and then it blocks like the sympathetic part of that branch, which regulates the fight flight, which is, so I just wanted to mention that. Fight and flight I mentioned earlier, which is part of the sympathetic branch, muscle, preparing the large muscle groups. Freeze comes in when both the parasympathetic and the sympathetic branches happen at the same time. When like escape is not possible, fight is not possible, that there could be a freeze. So a person could be highly revved up internally, like the engine running and revving, but their brakes are on too. So lastly, I'm not going to have time to go into this, but these are some of the CRIM skills, what we consider the basic 3 and help now. And tracking is foundational. Again, this is a biological model. It's about paying attention to sensations inside your body in the present moment, which can help people and enable people to help regulate their own nervous system. Some of the wellness skills are resource and grounding, all by checking in with sensations in the inside. And then I did want to, this help now, reset now is when we're out of that resilience zone, and it often engages the external environment. It's when somebody's bumped out. I did want to include this in here to help get them back in so they can engage all 3 parts of the brain and the thinking brain. And so these are things that can be done. If you want to learn more about the model, there is an app, the iChill app, and it is free. It's developed by the Trauma Resource Institute, as are these CRIM and TRIM models. It's available in these languages. It's actually all in the same app, or you can find it on ichillapp.com, and it talks about the different skills in more detail. And this is my contact information. The Trauma Resource Institute is for more information about CRIM and the iChill app. Thank you.
Thank you, Kimberly. We'll go ahead and transition now over to Abby, and I'm running your slides, right?
So. Thank you. So what we were going to talk about, you can go straight to 3. We're just looking at public health approach to relationship violence prevention. And I'm just going to go over the kind of broad strokes. Which is, we've decided to, in addition to kind of a longer standing criminal justice response to relationship violence, I don't know, about 30 years ago, we started looking at relationship violence, domestic violence as a public health problem and addressing it as such. And this made sense for a lot of reasons. First of all, because it is a very big public health problem. And second of all, because public health allows us to do more prevention of incidents, and sometimes, and law enforcement usually needs to wait till they intervene, after someone does something and then there's an intervention, someone gets in trouble or the family gets help or whatever. So public health is, this approach wants to do work before something happens in the first place. And there are public health models. There are going to be a couple pictures. You don't have to really think about them. If anyone wants to know anything, they can contact me. Denise knows how to get to me. So we can go to the next one. Okay, so a lot of the focus of prevention has been on primary prevention. Primary prevention occurs before as I said, before the violence happens in the first place. There are efforts to prevent initial perpetration and victimization. So those are, well, we'll see what they are. They can be policy change, they can be education campaigns, it can be individual skill building. There's a lot of stuff that go into it, but the theory is that, or the assumption is that we're doing this before anything happens. The thing about this model is we live in the real world, and there actually isn't primary prevention in the real world because the populations we deal with, just human beings, something has happened. They're not in a situation where they live in a world where violence occurs. So it's kind of something you have to hold in your mind. Different things is like, this is what we're doing. These are the goals, is to prevent initial perpetration and victimization. And we treat everyone in these efforts as if they have not experienced violence and know that it's possible that some people have. Okay, we can go to the next one. So a lot of this work has to do with modifying risk and protective factors that are modifiable. So that is like a risk. So like a risk factor for perpetration of violence could be low empathy, or it could be poor impulse control. That could be a individual factor. A relationship factor could be poor parent-child relationship, or being with peers who support relationship violence, having a peer group that supports joking about relationship violence, or as our first speakers talked about, people that support benevolent sexism, or people who exhibit attitudes that support hostile sexism. So those are risk factors for relationship violence that we might want to interrupt. So like a protective factor that we might want to encourage would be something like at an individual level, increased empathy, better impulse control. on a relationship issue, it could be kind of shifting relationships to improve relationships or relationships that value. I'm going to do a very quick example here. There's a nursery school a friend of mine, their kid goes to, and the school taught their kid this little song called the Boundary Song that like everybody sings, and it helps them interact with each other. And it goes, please stop. I don't like that. I'm feeling uncomfortable. I need more space. Not around me. Don't take it personally. It's just a boundary. It's just a boundary. So that already is teaching the little kids how to have relationships where they respect one another and where there's an kind of idea of consent and there's an idea of making boundaries. So that would be a protective factor. We can go to the next one. Okay, so when you're doing this, you want to be mindful of how things fit and nest together. So this is a social ecological model. It kind of describes how people exist in, there's a person that exists within the context of their relationships and their community and society. And these are all opportunities to affect risk and protective factors. And ideally, you would have activities in all of them because this is how we exist. And because the farther out you can go, like if you can make more community change, it can affect individuals. So you can do more work there and affect maybe more people. And public health has to do with population-based health, not so much individual health and individual wellness. So we're trying to move more towards population interventions we can do. We can go to the next one. Okay. So, and then there was a bunch of research on what is effective in prevention. And I have a lot of theories and opinions about all of this, so people can always ask me. But what we kind of decided, and this is based on a couple different documents, is that the programs to be relevant to the community, and that involves people who are building a program doing community assessment, and data collection and that kind of thing. Comprehensive, which means it should take place in all nests of the social ecological model. There should be activities in all of those things. Informed by evidence, and that refers to first like best available research evidence, which is things that have been tested, interventions that have been tested. There aren't that many of them, but it also means that if you're developing a prevention program, it should be theory driven. There should be some theory of change. There are a bunch of different theories. There's where people can look at both individual and cultural change. So it's based in one of those. You kind of have an idea of what you want to change and why it's going to work. It's a very big plan to just say, we want less relationship violence. So you have to zero in a little bit more about exactly what you want to change and then why what you're doing is actually going to affect relationship violence. And there are different theories and research you can kind of gather to do that. And then informed by evidence also means there is some outcome evaluation. So you're evaluating your program. Are you doing what you want to do? And then well implemented. And that has to do with trained staff, a good plan, and in terms of multi and things we know, multi-session curriculum or multi-activity programs, which means that just going in, what prevention used to look like is someone would go in somewhere to a church group or something and say relationship violence is not good, and they would leave. And why that is fine, it may not actually affect change, and that we do, now that we know a little bit more about what does affect change, there are some things about good programs that they have multiple contacts with people. So like a one presentation thing would not be as well implemented as something where you did an ongoing group for 8 sessions or something like that. I think that's it. I mean, that's like the basic public health model here is we're looking at preventing first-time perpetration and victimization. We're looking at modifying modifiable risk factors and protective factors. They're not all modifiable. Using the best available evidence when planning and implementing and evaluating programs, including some behavior change and having theories of change or a model of what you're going to do, and then just ongoing evaluation that informs your program and allows for continuous improvement.
Okay. Thank you, Abby. Okay, so I am going to take just a few minutes to go through some of the legal tools that we use here in the US to address domestic violence. I know because we had a little bit of a delay at the beginning, and we wanted to make sure that our colleagues from India, because they were joining from so far away, had plenty of time, that we are running a little bit late. And I do want to invite those of you who can stay beyond the end of the session to do that, because after I go, we'll have some of our students who have been really working on trying to apply this to a human rights framework, who will be sharing some of their insights. And it won't take too long, but I do invite you to stay if it goes beyond. So I'm going to share. Now I have to find mine. Okay. All right, let me go from the beginning here. Okay. I always have to get rid of this ridiculous bar up here. Okay, so I'm going to do a very, very brief overview of the tools that we use in the US that are legal, right? So we looked at some interpersonal or therapeutic tools. We looked at prevention. But like in India, right, we want to be mindful that there are legal structures and systems that are put in place for us to be able to address domestic violence. So the caveat here, of course, is that anybody who's paying attention knows that we are in a great deal of flux right now in the US, especially at the federal level. So what I'm sharing is really based on what we've practiced and known up until 2025, but things are changing, especially in terms of federal law. So unlike India, and we heard our colleagues in India talk about this, that there's only a India statute, right? There's only a country-wide statute. The US practices what we call federalism, which is a division of sharing and power between national and state governments. This means that the implementation and creation of law is divided between both the federal government and the state government. The federal government reserves for itself certain types of law that it finds very important, things like interstate commerce, those kinds of laws that promote capitalism, right? Or protect capitalism, quote unquote, protect capitalism, and things like immigration and foreign policy, while almost every other type of law is reserved for the state. So this includes things like public safety, health, family law, labor, education, etc. And much like our colleagues from India, our first laws were English law, of course, because of our colonial past, because of colonization here in the US. And that law looked at women and children initially as property. And the law explicitly said at that time that men must exert control within their household, and even went as far as creating a legal identity for married women only through their husbands, such as the law of coverture. But of course, through a great deal of organizing from women's groups themselves, some of the most, famous, I think, in the US were during the second The second wave, what we call the second wave of feminism here, which led to a vast majority of our domestic violence policy and established victims programs and services in the early 1970s, but even way back into the temperance movement, which ultimately led to prohibition in the United States, where women's groups were equating domestic violence with alcohol use. These were some of the first times that we saw women's groups actually developing domestic violence policy that might benefit them. So I'm going to very briefly go through both federal and state policy. Again, federal policy is limited in this area. Most of it is reserved for the states, but a couple of areas I did want to mention. The first is there are some firearms statutes that are built into federal law, and this is important because, as I'm sure everybody is familiar, we have our Second Amendment, right, which for domestic violence victims and advocates is very dangerous, right, the access to firearms. So it's important that this is built into our federal policy. And so, for example, people who are subject to a protection order or have a conviction for misdemeanor domestic violence can't have a firearm. And even in 2024, with our current Supreme Court in a case called Rahimi, the court, really supported this idea that it is not a violation of the Second Amendment, that there can be these limitations on access to firearms, especially as it relates to domestic violence. I also, because Abby had talked about, the efforts that have been made towards looking at domestic violence as a public health issue, I wanted to mention the Affordable Care Act in 2010. It's no secret that we don't have a healthcare system here in the US. Instead, what we have is an insurance system, and the federal government under the ACA plays a role in regulating that insurance system. And so in 2010, when that bill was passed, it was recognized that domestic violence and dating violence and sexual violence should be considered part of a national healthcare strategy because of the negative implications it had on victims' health. And it supported the routine screening and counseling of domestic violence victims and interpersonal violence, preventing health plans from requiring victims to pay for that type of service, as well as including it in early intervention screenings, like they would for obesity or alcohol abuse, etc. And it also prohibited insurance companies from discriminating against domestic violence survivors because of their history of domestic violence as a pre-existing condition. There are certainly other federal policies that enact certain victims' rights, for example, the right to be heard at a bail hearing or to have access to restitution. But I think probably the most far-reaching of our federal policy as it relates to domestic violence is the Violence Against Women Act. So this was the first time that gender-based violence had been viewed as having a systemic solution. Prior to the Violence Against Women Act, we largely looked at it as an individual issue. Early on, domestic violence advocates were concerned about its inclusion in a greater omnibus crime bill because there were concerns about the implications of mass incarceration, which of course turned out to be a reality. And I'll touch on that very briefly in just a moment. Excuse me. Within the Violence Against Women Act at a federal level, there are both criminal justice approaches as well as civil approaches. The criminal justice approaches require that domestic violence and other things like dating violence and sexual violence that the criminal justice response be coordinated, and not just coordinated between prosecutors and police, but also inclusive of victim services. So this was the first time that we saw efforts put into really sustaining victim services for domestic violence. The criminal justice approaches in VAWA created police and prosecutor trainings and created infrastructures like domestic violence courts or DV investigators. It did, of course, also promote arrest policies, which led to an uptick of these arrests and for communities of color and even survivors of abuse. Domestic violence advocates had advocated against that from the very beginning. But because it is a funding bill, it is up for reauthorization every 5 years, which means that it has to go through Congress again. And in the reauthorization, since its first inception, there's been an emphasis on restorative practices and moving away from prioritizing criminalization. In addition, there are civil remedies that are included in this federal policy, things like immigration protection for undocumented victims of domestic violence, confidentiality protections, support for victim services in a variety of places, a requirement for universities and colleges to include the prevention strategies that Abby had talked about earlier in their response to domestic violence, and that they have obligations to respond to sexual assault and domestic violence on campus. Full faith and credit, meaning that states in the patchwork of systems that we have to recognize and honor the policies and cases in other states, and also special domestic violence criminal jurisdiction for tribal courts. So very quickly, a vast majority of our domestic policy, because of this federal system, is actually reserved for the states, even when it comes to criminal justice and public safety. So in addition to this dual system of federal and state law, we also have a dual system of civil and criminal codes. Within the state, the definitions of domestic violence, sometimes they're quite expansive, are typically used for prosecution. We might see things like employment protections or campus protections, criminal justice responses like dominant aggressor assessments, and even mandates for healthcare workers. So in the states, because of their public safety mandate, we see that they define domestic violence for the purposes of prosecution. For example, in California, which is a very expansive law, we see that intimate partner is defined very expansively. Spouse, former spouse, domestic partner, former domestic partner, person you have children in common with, somebody who you live in with, someone who you date or have previously dated. While in Texas, there are limits, right, to that relationship that have to do with blood or affinity or biology or foster children, etc. States like Delaware might criminalize specific actions that might be part of domestic violence so that they can also reach domestic violence abusers that may not have this type of a relationship. So states use the tool of criminalizing specific actions like offensive touching or abuse of a pregnant female, or like in Illinois, the criminalization of stalking. And almost all states have some sort of criminalization of marital rape. States also apply civil protections. So for example, in California, labor protections prevent victims from being able to be discharged from their job because they take time off to go to court. In California and Colorado, there are protections from evictions, and Illinois actually creates an affirmative defense in the event that a victim gets evicted from her home as a result of domestic violence. Hawaii provides for a leave of absence for victims of domestic and sexual violence. Alaska has a mandate for all employees, public employees, in terms of how to identify domestic violence. And most states actually mandate some sort of training and reporting for certain healthcare professionals. Keep in mind that this is only a quick overview of state laws. There are very, very many in other states. And I just want to touch on one last thing before we transition over to the work of our students who have been really looking at the human rights implications of this. We often don't talk about the importance of defenses for domestic violence victims who find themselves in front of a court. Data on resistive violence and domestic violence indicates that while women are generally more likely to be victims, a significant proportion of women report using violence against their partners in some form of self-defense or resistance, especially if the abuse has been ongoing. Almost 100% of women's prison populations have some history of physical or sexual abuse, and women are disproportionately incarcerated for domestic violence cases as compared to their male counterparts, and their sentences have tended to be much harsher. There's no existing overarching defense to this resistive violence. So victims tend to use defenses like self-defense, which require a reasonableness standard that really is difficult to understand unless victims can do a full accounting of their experiences of abuse, which are typically not available to them. Keeping in mind that these defenses might vary based on states, just like other statutes. So the standard really is what we call a battering and its effects defense, which isn't actually a formal defense, but is instead a legal strategy that's used in criminal cases where the defendant, who's a victim, might argue that their actions were a direct result of physical or psychological abuse from another person, which resulted in them resorting to the crime and having to defend themselves or otherwise commit a crime under duress. This isn't a standalone offense. It's not a separate offense, but instead is a way really to defend or to explain the victim's mindset. There are a lot of challenges with this type of offense, especially as it relates to establishing a pattern of abuse. The victim really needs to provide substantial evidence of a consistent history of violence, which can often be difficult to do. And juries are often skeptical of this defense, especially if the victim hasn't previously notified the police or authorities. And I just want to highlight that in 2019, New York State actually passed the Domestic Violence Survivors Justice Act, which did just this, right? It expanded the situations in which a judge can consider domestic violence survivors' abuse in determining appropriate sentences for a variety of offenses that they've committed. Okay. So that was a really quick overview, and I want to be aware that we are at the end of our time, but I want, if you are able to stay on so we can turn to the work of these students who have been, thinking about the human rights framework as it relates to domestic violence. So usually when we think about domestic violence, we think about it as an individual issue. And so it becomes difficult, right, when we try to incorporate that into the obligations of states. But as a result of the work of the brilliant advocates in the Beijing conference who recognized that it was really critical to connect private actions to public obligations to ensure women's access to freedom, safety, and equality, Today, in international law, we view domestic violence as discrimination, as laid out in CEDAW. We view it as torture, subjecting states to the Convention Against Torture's due diligence standard. And we even view it as a violation of the right to life, impacting the quality of life for the victim and infringing on what's promised in the ICCPR. So now we're going to turn to the student scholars from the California State University Northridge's Criminology and Justice Studies Department who've been exploring this issue and will share with you some of their work in this area. So we're going to turn to the first set of speakers for the group related to Indigenous women and domestic violence. Emily, we're unable to hear you.
Oh, here we go. Sorry.
Gotcha.
Hello, my name is Emily, and my co-presenter Elias and I are going to be representing on behalf of our group for Indigenous women's rights and their violations. Domestic violence against Indigenous women is deeply rooted in structural issues such as gender-based violence, loss of control, discrimination, marginalization, oppression, and political violence. Amid the administration of executive orders, the eradication and overview of DEI programs has affected the access of Indigenous archive records. In addition, the jurisdictional issues that Indigenous communities face impact the lack of sovereign database to address domestic violence, missing, and murdered Native women. Statistics show that homicide rates for Alaska Native and Native American women are over 10 times the national average in some regions, and overall 2.8 times higher than those of white women. Native women in the U.S. face higher rates of battering, rape, and stalking than any other group. 34% will be raped in their lifetimes, and 39% will experience domestic violence. 84% of Alaskan and Native American women have experienced violence in their lifetimes. The state recognizes Indigenous women vulnerable to violence and discrimination. This recognition is codified in United Nations Declaration on the Rights of Indigenous Peoples, specifically in Article 22, addressing the state's responsibility to ensure Indigenous women and children's rights to full protection and guarantee against all forms of violence and discrimination. Violence Against Women Reauthorization Act. The Violence Against Women Act was established in 1994 but did not include tribes. The 2013 reauthorization of VAWA included Title IX safety for Indigenous women. VAWA's goals include reducing violent crimes against Alaska and Native American women, ensuring that those responsible for violent crimes are held accountable, and improving tribes' ability to exercise sovereign authority when dealing with those crimes. The United States needs to properly address the human rights violations Indigenous women face due to its failure to provide and uphold adequate protections of their identity and culture.
The states failed to recognize Indigenous Women in Human Rights Convention. As a signatory of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, the state recognizes and upholds these rights but refuses to be held accountable for violations. CEDAW falls short on the inclusion of Indigenous women, failing to recognize them as women protected under this convention. Missing and Murdered Indigenous People Crisis. According to the U.S. Department of Indian Affairs, approximately 1,500 American Indian and Alaska Native missing persons have been entered into the National Crime Information Center throughout the U.S. Approximately 2,700 cases of murder and non-negligent homicide offenses have been reported to the federal government's Uniform Crime Reporting Program. In total, BIA estimates there are approximately 4,200 missing and murdered cases that have gone unsolved. The state fails to recognize and address and investigate the cases surrounding the murder and disappearances of Indigenous women despite such drastic numbers. Our recommendations include inclusion of Indigenous women in CEDAW and its ratification. The state has yet to ratify its obligations under CEDAW, resulting in their ability to violate women's rights without being held accountable. In addition, its lack of explicit recognition of Indigenous women throughout its existence has led to and disservice to their specific. Create a sovereign database. Indigenous peoples need proper funding and resources from the U.S., to build and own a system to access and manage to ensure data protection, accuracy, and usage in investigations. Indigenous data sovereignty will help address the crisis of missing, murdered, and domestic violence women face. Petition Congress to abolish outdated laws. Congress must appeal unfair laws that provide state criminal jurisdiction over indigenous land and advocate for long-term policies and legislations that allow tribal nations to make their own decisions towards protective measures. By working together, we can ensure that indigenous women are fully protected from violence and discrimination and that their rights and identities are respected and upheld. Thank you for listening to our presentation.
Okay, thank you. All right, so we'll hear from the second group of students who's looking at domestic violence and other social issues that are linked to it.
Good morning. My name is Steven Espinoza, and my co-presenter is Lisandro Alvarez. And today we will discuss a critical and complex issue impacting countless individuals and families across the U.S. Domestic violence and its connection to child abuse, child care, and substance abuse, highlighting how these problems are often intertwined and perpetuate a cycle of harm. Domestic violence is not just a private issue. It has far-reaching effects that extend into child abuse, child care, and substance abuse. Children who witness or experience this sort of violence at home often suffer long-term emotional and psychological harm, impacting their development and well-being. In unstable or abused households, proper childcare can become neglected, putting children at even greater risk. Addressing domestic violence means tackling these interconnected issues with comprehensive support and intervention. Moreover, statistics reveal that 1 in 4 women experience severe intimate partner physical violence, and 5 to 35% of children who are physically abused, and 10 of 20% of children have witnessed domestic violence across the duration of their childhood. This impact of domestic violence extends beyond the immediate victims. It also affects the children who witness it. It also has broader issues such as the barriers that prevent them from seeking help, including fear of retaliation, lack of resources, and societal stigma. Additionally, substance abuse is frequently intertwined with domestic violence and child abuse, as individuals who struggle with addiction may resort to violence as a means of coping with their issues, leading to a toxic home environment as it could lead to impaired judgment and increased impulsivity, making it more likely for abusive incidents to occur. Furthermore, the presence of substance abuse can hinder proper childcare as parents may neglect their responsibilities, putting their children's safety and well-being at risk. Lastly, the links between domestic violence, child abuse, child care, and substance abuse creates a complex web of challenges that must be addressed. It's crucial that we present this issue in order to break this cycle of violences and in order to start providing support to those affected, and to work towards a future where families are safe, children can thrive, and individuals can heal. With that in mind, I'd like to pass over to Lisandro, who will discuss the legal obligations the U.S. and international nations have concerning these issues and recommendations to mitigate these issues.
Thank you, Stephen. We must address the family-breaking and systemic issue of domestic violence as well as the mental health issues surrounding domestic violence. While some institutions in the U.S., like the DCFS, Department of Children and Family Services, have intended obligations to protect children, they frequently cause more harm to victims as the family is torn apart in the process. Family removals have led to children of domestic violence victims becoming caught in the vicious cycle of abuse. Unfortunately, many children placed in foster care face further abuse within the system. In many instances, mental health is a key factor in domestic violence cases that social services like DCFS handles. Parents struggling with addiction and mental health crisis often resort to violent behaviors, creating a toxic environment that endangers children. In homes where mental health is present, children may not receive proper care, nourishment, or emotional support. The U.S. has legal obligations under several international human rights instruments that address issues related to domestic violence, child abuse, and the treatment of children and families. Under Article 24 of the International Covenant on Civil and Political Rights recognizes that the right of every child to be protected from abuse and exploitation, which includes domestic violence and neglect. The U.S. is obligated to provide adequate protections for children from all forms of violence and exploitation. Under Article 3 of the Universal Declaration of Human Rights, it guarantees the right to security and protection from violence for all individuals, which includes children living in abusive homes. Article 25 of the UDHR recognizes that families have the right to special protection and assistance, and that children should be entitled to care, security, and protection from violence and exploitation. Despite these obligations, the U.S. has often fallen short in implementing adequate protections for these matters regarding human rights. Drawing from successful programs around the world, the U.S. could improve family support systems by implementing family-oriented services that include substance abuse treatment, mental health counseling, and parenting support. For example, in Finland, a comprehensive social welfare system focuses on preventing family breakdown by offering support services directly to families in need. This could reduce the need for child removals by helping families heal before children are placed in foster care. The U.S. must also expand substance abuse rehabilitation programs for both parents and children. Countries like Portugal have shown success in decriminalizing drug use and investing in treatment programs, which focuses on rehabilitation rather than punishment. Countries like Canada have adopted integrated care models where substance abuse treatment, mental health services, and domestic violence support are offered through the same service networks. These models help ensure that families and domestic violence victims receive a wholesome and individualized support rather than dealing with separated systems that don't communicate or address the issues all at once. The U.S. could adopt a similar system where caseworkers collaborate with social services, substance abuse treatment programs, and child welfare agencies to create a seamless, supportive, and environment for families in crisis. Addressing the interconnected issues of domestic violence, child abuse, and mental health related concerns requires a complex and interconnected solution. The U.S. must meet its international obligations to protect the rights of children and women. Thank you.
Okay, great. Thank you. And the last group is going to talk to us about the criminalization of domestic violence victims.
Hello, my name is Evelyn.
Evelyn, we're having a hard time hearing you.
Co-presenter Derek Bonilla and I will be presenting the criminalization of domestic, the recommendation. Yes.
Go ahead. Okay, try it now.
Okay, could you hear me?
Yes. Oh, we're still getting some delays.
Yes.
Just go ahead. Go ahead.
Let me see. Could you hear me or no?
Is that it?
Just go ahead.
Can you hear me now or no?
Yes, we can hear you.
Okay.
We can hear you.
Okay, sorry about that. So my name is Evelyn Velasquez and my co-presenter is I'm so sorry. And I will be presenting the criminalization of domestic violence victimization and the recommendations to improve this issue. What is criminalizing domestic violence victimization? In many cases, victims of domestic violence find themselves not only enduring abuse, but also facing incarceration or legal punishment. This situation is a growing concern in the United States, where the criminal justice system has at times failed to adequately support survivors. The criminalization of domestic violence victims is a significant and ongoing issue, highlighting the urgent need for change within our system to better support those who suffer from abuse. Domestic violence, a serious violation of human rights, is not only a personal or social issue, but a legal one. The United Nations has made it clear that violence against women is a human rights violation, specifically addressed in the United Nations Declaration on the Elimination of Violence Against Women, which recognizes the necessity of state intervention to prevent such violence in Article 4. Despite this international recognition, women in the United States often face additional harm in the form of criminalization, which further compounds their suffering. The United States has a responsibility to uphold the principle of justice, where every citizen is entitled to the presumption of innocence until proven guilty. However, the criminalization of domestic violence victims stands in direct contradiction to this principle. Research shows that more than 70% of domestic violence victims, particularly women, end up incarcerated, demonstrating the alarming prevalence of this issue within the criminal justice system. This issue is further compounded by the failure to consider the dynamics of domestic violence during legal proceedings. The International Covenant on Civil and Political Rights guarantees equal protection under the law in Article 26. However, failure to recognize the specific nature of domestic violence can result in wrongful arrest and convictions, disproportionately affecting women. Too often, women who are survivors of abuse find themselves wrongfully arrested for acts of self-defense rather than being seen as victims of violence. Furthermore, coercion and abuse often increase women's vulnerability to criminalization. Domestic violence survivors are sometimes coerced into committing criminal acts by their abusers, further complicating their legal circumstances. Article 14 of the ICCPR guarantees the right to a fair trial, but this right is frequently denied to domestic violence survivors who face charges due to actions taken in self-defense.
All right. Despite the agreements such as the EVAW and the ICCPR, the United States is not adequately ensuring the protection of domestic violence survivors, particularly in preventing their wrongful criminalization. In many cases, women who defend themselves from abusers are charged with assault, attempted murder, or even homicide. This is a failure to recognize self-defense undermines their basic human rights and legal protections. Furthermore, domestic violence disproportionately affects women of color in the United States due to a complex interplay of factors, including racism, systemic discrimination, and cultural stigma, often leading to barriers in accessing support systems and leaving abusers, with many feeling distrustful of law enforcement due to experiences of racial profiling, making it difficult for them to seek help and receive adequate protection. To address systemic injustice, it is crucial to implement 3 of following reforms to ensure protection against wrongful criminalization of domestic violence survivors. Law enforcement agencies should adopt survivor-centered policies. These would prioritize investigating abuse claims before pursuing criminal charges against victims. Domestic violence survivors should not be penalized for defending themselves from an abuser. Second, recognizing self-defense for domestic violence survivors. Self-defense laws should be reformed to explicitly include protections for survivors of domestic violence. Judicial proceedings must take into account the history of abuse and the immediate threat faced by survivors when acceding claims of self-defense. Thirdly, eliminate mandatory minimum sentences for survivors defending themselves. Judges should have the discretion to consider the full context of abuse when determining sentences outcomes for survivors who defend themselves. Eliminating mandatory minimum sentences would allow for more just and individualized judgments. In conclusion, the criminalization of domestic violence victimization is a crucial issue that disproportionately impacts women, undermining the core principles of justice. Women who suffer abuse are often met with further victimization through wrongful arrest, prosecution, and incarceration, especially when attempting to defend themselves. This systemic injustice perpetuates a cycle of fear and silence, preventing many victims from seeking help. To break the cycle, legal reforms must be enacted to ensure that survivors of domestic violence are not criminalized for actions taken in self-defense. By implementing survivor-centered policies, reforming self-defense laws, and eliminating mandatory sentences, the United States can better uphold its human rights obligations to protect the dignity and safety of domestic violence survivors. International human rights standards, such as those outlined in the DEVAW and ICCPR, should serve as a foundation for these necessary changes to create a more just and support system for survivors. Thank you for your time.
Thank you. I know I can speak for everybody when I say I look forward to the day when you are all in charge of the world. Okay, so thanks so much for those of you who were able to stay to the end. I know that the students had done so much work on that, and I appreciate your time. So we only have a very brief moment for closing. We want to thank you for joining us today. There are some materials that are available on the conference site. If you want to explore this further, please feel free to ask any questions there as well, and I'll do my best to direct them to the folks that can answer them. We hope that you found today something that spoke to you. All ideas that were offered today were offered with the openness of adaptation. So while things may not work for you directly in your state or city or country or municipality, we hope that you found something that sparks an idea. We also have raised issues that we hope inspire you to hold all of our governments accountable for their obligations to recognize women's humanity both outside and inside the home. We've identified gaps in governmental systems and structures, and we encourage you to find out more information on any of the topics that we've raised today. With continued collaboration and efforts like the ones that we've put forward today to lift the veil on domestic violence, we inch closer to a world where women can enjoy their human rights and fundamental freedoms. Thanks so much for your participation, and we will see you next year. All right, everyone.